This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Wait, this is Dr. Miller. May I discharge the home task? The spiral binding, page 237. That has been a basis in the judgment for saying that persons who have done very bad in academic results, they have been given high aptitude marks. But the first question is the spiral binding is at all reliable by the judge? A learned judge should have relied upon it or should have ignored it. And you see the spiral binding, page 237, volume 1.
873 paper, volume 1. Wooded appeal paper.
What is the authenticity of this spiral binding? What authenticity? It has been page. It starts from page 123, volume 1. It is prepared by the writ petitioners, litigant. No, nobody has placed his oath on the correction on this document. Volume 1.
Nobody has?
Volume 1, Milord.
Yes, we got it.
Page 123.
Yes.
It starts. See, Milord, it starts. What is the good? But nobody has placed his oath. There is not supplied on supportive affidavit anything. Just place both the court at the time of middle of the hearing.
Yes, that was accepted by the board.
Accepted by the court, and
you were not parties to the writ petition.
Board has court has accepted. My humble submission is, and board as usual did not do anything, kept quiet. Board did not object anything.
Yes.
But board did not object. That doesn't mean I cannot object. Appeal is a continuation. I'm very short on that. It is a document prepared by a private party without not supported by any oath or affidavit anybody. Now I'm going to see what the purpose of this 123 starts. Page 123. Serial number 1. Heading 2014 TATE and 2016 recruitment process. Vacancy was 42,949. That figure is correct figure. Similar. Now, what is the first objection? This is primary TATE 2014 লিখিত পরীক্ষা OMR sheet তৈরি এবং তার মূল্যায়ন করার বরাত পায় বাসু রায়চৌধুরী বাসু অ্যান্ড কোম্পানি। কিন্তু লিখিত ভাবে পরীক্ষা নিয়োগ আবেদনপত্র এক্সেট্রা how is it relevant?
No, we have taken note. This is an unauthenticated list of documents which reliance was placed by the learned judge, which ought not to have been done.
Yes.
This is your court. Yes.
Yes. So, but this is first serial. The primary TATE, there's a corruption or illegality, not in the 2016 selection process. Please see the first document. Primary TATE 2014. That was prepared by Basura and company. How is that relevant while considering the validity of...
That is because that TATE qualification was essential qualification for
TATE qualification is different thing. TATE qualification is not challenged here. Different period.
No, that is not being said here. It is only an information. Are you disputing this information?
Yes, certainly.
So you mean to say
Tell me,
no TET was
this is
sent?
my primary TET examination results is subject matter of another writ petition pending in this court.
Maybe.
Pending.
But you are not disputing that TET 2014 eligibility was the subject matter of selection process.
No, sorry.
Yes.
That's right, my lord. But eligibility, there is no complaint that
All right. There was no complaint as regards the TET.
no allegation in the writ petition that the persons who were qualified by 2014 TET were not eligible.
That is not the.
Then why? The question is all the corruption, etc., allegation also find a petition is all regarding 2014 TET, not regarding 2016 election process.
Yes, that is also included, Mr. Mitra. We
Therefore,
understand that TET 2014 was not the subject matter of challenge of this 2016 recruitment. This ought not to have been taken into consideration by the judge, more so when it is not supported by evidence.
Judge is legitimate, obliged to lordship. Therefore, my lord, when my lord thinking of corruption and say that when I see a corruption, should I keep my eyes shut? Corruption, say by committed by A, on respect of A, for that B will suffer. There is no charge of corruption in respect of 2016 election process. I shall come to repeat show you, lordship. I have to disabuse my lord's mind about corruption in 2016 election process, selection process. Is there an allegation in the petition? I'll come to that immediately. I'm now come to me of this, see what concoction is there in this petition. Please come to page 237. My lord wanted me to make submission on this. It is not.
That we will ask the board, Mr. Mitra. We thought of placing that, but that the board should answer to us. We are not going into that. So
yes.
Will you take us to the judgment? Do you have that corruption? Will you read that? Will you place that? Judgment 8 and
I'll come to that. Judgment. I'll place by 1822. I'll only place that now, right now. I will place it. I want to show it, lordship.
As you wish, Mr. Mitra.
No, then can you, lordship, raise the question 237? See,
237, we are not asking you now. Because you are not parties.
But I have to show. Lordship may not ask. I have to support my case. That this petitioners made an illegal and untenable charge. What they are showing? They're manipulating documents. I just show you, lordship.
Are those your grounds?
These are manipulated documents. This is not original RTI sheet. See this document.
Yes,
it's not original RTI sheet. It's not signed by anybody.
That I pointed out to you now.
This is not in the pleading apart from that. RIT report against it, retype by them.
Is that your ground of challenge?
It is
not
your
application. Is that your ground
of
challenge?
It's not an affidavit.
In your leave to appeal which you preferred, did you take this ground? Mr. Devbarman, why you are saying to Mr. Mitra, is that a ground in your appeals, leave to appeal? No, I'm saying, is that a ground?
That was not available to the appellants at the time of preparation of stay or memorandum.
Very good. That will be your reply only. We have not asked you to deal with that document. That is what we are asking.
Lordship, the last question Lordship asked me to. What may I shortly show me that incorrectness of this? What is there asking for question? What is the question? Similar. One thing will be clear. Read one by Siliguri District 1. What is the question to RTI? Just once a question. How many candidates, trained and untrained? Can you see one paragraph? 237, question, all the same question. Question 2, how many candidates trained and non-trained, para teacher, plus case petitioner? What is the case petitioner? You've been told. It is a case petitioner. Have been appointed by Siliguri District School and Primary School, including all categories of all medium with memo number blank dated between 24/9/2016 till 11 January 2017. So 2021. Selection process in 2016, my lord, kindly note, is stopped in April 2017. But they're asking for how many candidates after 4 years after selection process stopped, how many candidates were untrained. So why? This is to what purpose? Vacancy was 42949. And according to the learned judge, 32,000 persons were employed to fill up this vacancy of 42,000. Therefore, no employment given beyond the vacancy limit under the 216 selection process. On their own admission, there is nothing given. Am I clear, my lord? The one ground is you are given employment busting the vacancy limit.
So your contention is there was no appointment beyond the vacancies advertised.
Vacancy beyond vacancy limit in the selection of 2016.
Very good. What is that number according to you?
This is the number they have given 429. According
you say we will.
I say according to the judge, 32,000 employees. That is the order.
Yes.
Therefore, 32,000 persons are employed against vacancy of 42949.
Yes.
So there is no question of over employment. But I think that
is not a ground for setting aside the selection process, Mr. Mik.
That is not the ground.
Not the ground.
That is not the ground. Very cool. Then I'll stop here.
Yes.
I'll come to that.
That is in paragraph 18.
Then, Miller, I shall go as by my lord want me to. Can you paragraph 17, 18, 19 of judgment? Yeah, judgment. If my lord agrees this file has no effectiveness, I'll stop there.
Why do we say so? Because in the writ petition which they filed, subject to correction,
Yes.
we didn't find any allegation that appointment was above 42,000. On the contrary, they said that there are existing vacancies. You accommodate us in those vacancies.
I have no objection to
Yes,
that.
that is
What objection can I have?
Exactly.
I'm not stopping their employment.
No,
They have stopped my employment. But I'm not vindictive. Let them have as many appointments as they like.
They will become my friends. Later they will become my friends.
Mr. Gupta, that is a fact, na? That there was no appointment beyond 42,000.
No. That's not the case of any. That's not the case of any.
That they will explain to us. They will explain.
No, we are in the selection process of 2016.
Yes.
Admittedly, the vacancy of 42,000 odd and appointment made according to the learned judge 32,000 only.
Yes.
So therefore, no question of. So
Excess
apparently, Miller, after April 2017, further appointments are given. Maybe by the board. Maybe. That is their case. That is their case.
That is by virtue of court orders.
That is their case.
17, the appointments that were given were pursuant to the court directions, specifically.
That is it.
That was not told by Mr. Dotto. His argument, this point was not. Anyway, you will give your reply.
Anyway, Lordship is now verifying the selection process of 2016. And my lord, will you please to ask me to consider paragraph 17 1819 or only 1819? 18 to 22. This similar was 18 to 22. Can you page 623 of volume 1? What is the corruption involved in 2016 selection process?
Mr. Mitra, I'm sorry, it should be from 17.
Right, that's my lordship. 17 or not 17. Please, that's it. From the gross illegality in the selection procedure in the recruitment exercise conducted of exercise 2016 conducted by the board, it is clear that the board is official, including former president. Did it? So, gross illegality in the selection procedure. What are the gross illegality? As shown in the judgment? Six. First one, 832 candidates below the lowest mark. I've dealt with that.
That you have said.
That could be a wrong low mark. Gross illegality, you were confined with judgment. On what ground court holds that illegality?
That you have explained to us.
Yes, illegally, not corruption. Illegality in the procedure, violation of rule, etc. Corruption is a media creation. Now let's see. Six instances given. I shall deal with each and every one. So is not sustainable. What is sustainable? Suppression by the board. Why? Because board has not produced a document, which according to judge, I have shown the document was produced, disclosure particular given, but my lord, kindly see as a judge, if the respondent does not, suppose respondent suppress a document, what's the consequence in law? Petition will be allowed. So, respondent has suppressed a document according to learned judge, which is incorrect on fact also. But what's the but that petition will be allowed by making orders which are not prayed for in a petition. Law is right. Let me finish this.
Yes, the paragraph, then you argue.
Okay, very
Second person, please place.
Election process illegality conducted board is clear. That the board, its officials, including its lower in former president, Mr. Manik Bhattacharya, I'm told is a one, who is now in custody after arrest by enforcement directorate for transaction of huge money in the recruitment procedure. In which procedure? Lordship doesn't say in the selection procedure of 2016. That's because he was in connection with TATE 2014 selection procedure. And he is not yet he is now released on bail, he is not yet been convicted, found to be convicted. Now, my lord will consider whether it is relevant to consider this factor while deciding the validity of the selection procedure 216. That the president was arrested and in arrest in connection what? Suppose he had committed theft. Yeah, he arrested for that. And that will vitiate the selection process, a public selection process. He does not say he has been taken in custody because of something wrong done by him in 2016 selection process. Doesn't say that. It comes to the next, if I read on. If he said, Lalne just said, if a president is arrested for doing something wrong in respect of 2016 selection process, I could understand the relevancy. No. Then in the mandatory process, conducted the whole affair as a local club. Now is gradually coming to light by investigation of enforcement directorate that jobs for primary school teachers were actually sold to some candidates who had the money to purchase the employment. Similar. Why is any instance given? then a corruption of this magnitude was never known in the state of West Bengal. Okay. But please analyze me. According to him, jobs were sold for money. Very good. There is no basis for, no instance even anywhere. Judge has not been able to say that jobs were sold in connection with 2016 election process.
Yes, we have taken note of that.
Yeah.
We have taken note of that.
Yes, yes. Similar, this is paragraph 17. So my humble submission would be, in paragraph 17,
This has no relevance. This has no relevance.
does not make out any case of corruption.
Yes, that was the first.
Of corruption in respect concerning 2016 election process. Does not make out a case of corruption to 2016 election process. If corruption happened in respect to another selection process somewhere else, that should not vitiate this selection process. Now I shall come to the petition spoilers. Then paragraph behind the bar, CBI inspection, then befitting that. Paragraph 18 shall I read now? It is a matter to be noted that the board in its affidavit in opposition, while dealing with the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principle of law, but however nice or however laudable these principles may be, this court, as a court of justice, will fail to deliver justice, knowing fully well that sense of justice is much above sense of law. If the writ application is thrown out on such nicety of law, as this will mean that in the name of preserving the law, corruption would be proceeded, which is a constitutional court can never be keeping in mind the soul of our constitution and constitutional conscience. I must say that in this scam, excellent paragraph. Now it has got 2 points. Let me analyze what the judge holds. 2 points. Firstly, that there is an allegation of corruption in respect of this selection process of 2016 in the writ petition. I say it is none. There is none. I show you. And second is, my lord, a very, very fundamental question of law. I hope Lordship will consider whether agree or not with this. That the sense of justice is above sense of law. Justice without law. Rule of law has no place in my country. Basic structure of constitution, rule of law. And can you deliver justice contrary to law? This is the provision of law. So will kindly sitting in the highest appellate court of the state. Will examine this. Will the sense of justice above the law? The court should deliver justice regardless of law. This is the provision of law. How drastic it is. It doesn't require an argument to be rejected. This is the basis of the judgment of a learned judge of this court. Now let us see first thing, what the allegation of corruption in the writ petition regarding this. Can you take the writ petition, volume 1, see paragraph 17, page 42, volume 1. And see, charge of corruption in respect of what?
You're placing from your paper book or from 873 paper?
Huh? Both. Both. I'm leaving both. I shall tell you when going both. Both paper book, depression, volume 1, page 42, paragraph 17. This is the only paragraph we have found. The alleging corruption. The scam allegation is paragraph 17. Your petitioner states that State 2014, kindly mark this, is the biggest scam of the Education Department of West Bengal. And in this case, the Minister of State of West Bengal, MLA, MPs, leaders of ruling party are involved. So, they are all involved in the scam of TET 2014. And meritorious students who qualified for the job did not get chance. And after talking to the candidate, petitioner came to know roughly 14 to 20 lakh rupees were taken for giving in TET 2014. TET 2014. Some people did not get job even. Similar allegations confined to 2014 TET. And that is why in the spiral binding, they have referred to 2014 TET. Serial number 1. That is why I am placing that serial number 1. Their case is not that. Any scam in respect of selection process of 2016 is not the case. Lordship, remember showing the scam that page 123, page 123 volume, this same volume, similar, is 120 of same volume, can you see? That is the primary TET number.
Yes, we have seen that.
I've seen that. So when the learned judge says, board did not delete the allegation regarding corruption made, so learned judge is in a humble submission, my lord, had inadvertently missed or made a mistake that no allegation of scam was made in the petition regarding 2016 selection process. That was regarding 2014 scam. And Lordship consider whether in view of that, is it open for any judge to make it as a serious conclusion that the matter of scam? He is concerning the validity of selection process. And kindly Lordship knows that this selection process or the selection of candidates was challenged 5 years after conclusion. So they knew everything about selection process.
And that too without implementing it.
That's right. Therefore, it is not the case. They came to know of this 2016 selection process after making the petition. This cannot be. They have done so. This is paragraph 18. Paragraph 19, may I now read?
All the writ petitioners are also TET qualified. All the writ petitioners are TET qualified.
Or
they cannot raise a plea that put the 2014 case.
But I don't agree with you, Mr. Lokhi. If they not agree, they must raise the plea, this plea of the grievance in another proceedings, which is now pending in this court, not in this proceeding. This proceeding must be confined to this matter. My submission is, if any grievance about the TET 2014, they have the application challenging 2014 TET election, and or join in the writ petition which has been already made and the list of honorable judge regarding 2014 TET, and let them join there or write a fair petition saying that all selection in TET, including the writ petition as well, void. Let them say that we are all elected, we are all selected void. All my selection in TET 2014 is void. They're taking advantage of the selection 2014 process so far as they are concerned. They are not saying our selections are void. And now challenging that in another proceeding which is not relevant. And thereby prejudicing court's mind. That the impartial judge like Gangapat's mind is being prejudiced. Now see paragraph 18 below. Paragraph 18 only come to. 18 ground. Your petitioner states that a board has stated in different cases filed before this honorable court that 442,800 candidates were selected till date. Till date, not up to selection process of February to April 2017. Till date. Till date is date of filing with the petition 26 September 2022 till date. Paragraph 18, my lord, page 42. Your petitioner states the board has stated in different cases. My lord,
You are placing 18 of the
volume 1 petition. I'm reading past 17, 18, 19. I shall read it. And really, Ugasu Lordship points to hit the core of the matter. Your Lordship indicated.
Yes, correct.
18 now. Your petitioner states that the board has stated in different cases, not in these any cases, filed before the Honorable Court, that 42,897 candidates were selected till date. Till date means 12 September 2022. That is date of filing of writ petition, affirmation of writ petition. And our selection process of 2016 selection process closed in April 2017. This is selection process 2016 closed in April 2017. Last letter of appointment issued after that. And they're talking till date. Well, then what happens? But no merit list of 42 candidates was ever published by the board. So, board should be directed to publish a merit list as a prayer made. Disclose the merit list. I understand. I have no objection. The order being passed. But learned judge rejected this prayer, did not pass any order. I'll come to prayer in different show. So which is regarding no such finding by the first court of first instance, that merit list should have been merit list are prayed for, and they did not publish, and therefore the board has done something wrong. Board has done something wrong must be in connection with the concerned selection process of 2016. It's no good saying the board has done something wrong in 2014 TET selection process. It's Aesop civil. You have not done it, your father has done it. And you are responsible for father's job.
You will be affected by your father's sins also.
Father's sin. Father's sin visited upon son. Father's sin visited upon son.
Yes, sir.
Go on, my lord. Did not qualify. My lord, the process was not completed in 2017. Department is well aware that Honorable Court should take notice of some persons who did not qualify, did not qualify for TET 2014, were appointed as primary teachers by the board. When? Not under this selection process of 2016. They are appointed as judge, and Mr. Gupta shows now relevant to show. Because the judge are directed appointment from time to time. This very learned judge.
There was no challenge against your appointment also in the prayer. We have heard that. We have taken note of that, Mr. Mitra.
Taken note of
that the judge on the basis of the honorable judge on the basis of a writ petition in which you were not parties, the selected persons who got appointment.
That is one thing.
Random said that in such circumstances, 32,000 out. The first submission which was made before us, that is there any prayer towards cancellation of any person's appointment? There is no such prayer. That they will satisfy. That when the domain of the writ petition is within this, that is what you have argued also. We have gone through the
I'm obliged to my lord for remembering a submission.
Mr. Mitra, we wanted an answer that, like in upper primary, I think in one 26,000 persons where appointment was cancelled. In that case also, the allegation was there was corruption. And ultimately, subject to be corrected, it was held that as we cannot differentiate between who got the benefit and who did not get the benefit, we are cancelled. Now, that is why we wanted to know that what is your answer to the allegation of corruption, jobs were sold ineligible and unqualified candidates?
In answer to it, I am showing me, Lord,
Yes.
there is no allegation of corruption.
You have shown us that. So we can
Yes, sir.
proceed, Mr. Mitra.
Therefore, that was not shown to you, Lord. There is no question answer that arises.
Yeah, no, your argument is not. Your argument is that corruption issue does not come because
Yes.
there were 6 illegalities which were there.
Yes, sir.
On the ground of an illegality, can you brand a process to be a corrupted process or not? That is your argument. We understand.
But my submission is, there is no allegation of corruption in respect of 2016.
And 2016, which you have
And
said.
when the learned judge holds in paragraph 18, there is a scam, stinking rats are being smelled, is totally unjustified. This is my submission. May these observations do not affect my lord's conscience in the appellate court. In view of stinking corruption in recruitment 2016 proceedings, the judgments are not applicable. Similar to what the judge is holding. All the
Yes.
judgments cited are not applicable because there is magnitude of stinking corruption in recruitment exercise of 2016 conducted by the board. It is nobody's case. And then the judge has not been able to give any single instance of corruption in 2006 selection process. Another very high principle law has been laid down. If in a case of corruption is raised, then the judgments are not relevant. You are the highest court of appeal. In this court, you have to support this. Judgments are not relevant, judgment court not relevant if a charge of corruption is made. This is the law. Then just corruption and then This is the basis of the judgment. There is a list of cases he is not mentioning. Then, can we come to paragraph 20 now? The affidavit in opposition of the board was filed when all pleadings and petition of the petitioner, including particular suppliers in court, were served and kept on record, and board did not deal with these allegations and those material facts necessary particulars. Repeatedly, Mr. Lottery is saying that without telling the in a judgment, the allegations have not been made in the petition. And all the points, the grounds alleged illegality is a judge's point.
Yes.
So the basis of the judgment is based on irrelevant considerations. Incorrect assumption of pleadings and facts.
Yes.
In the what order is being passed? Similar last paragraph 21. And 22 are the paragraphs. In such circumstances, I allow the writ petition. Very good, allow. Allow all the prayers. I don't mind. Then why? The appointment
the
of
prayers are allowed even if all the prayers are even allowed. 36,000 remains.
All
the prayers, if allowed even.
Even then, let me show you, Lordship, the prayers. I show the prayers. I don't make any argument with court. I don't argue with court. I make my submission to court.
Saying that. You have shown us the prayers.
Yes. May I read the order? Allow the petition. In what? That I show you, Lordship, what petition prayer have been allowed. This is the order. Appointment of all 36 candidates who were untrained and at the time of recruitment of 2016 recruitment process conducted by the board in the primary teachers are cancelled for various reasons as have been elaborated above. Very serious order. What are the Barcode? So, that whatever may be the ground, if my laws are convinced the selection process is totally illegal, no order can be passed against non-parties with a suit affecting their employment. There is settled law and judgment has been cited. If you know, I've filed more judgments. This order of annulment of appointment of 36 candidates who are not parties have to be cancelled, Milong, in violation of national justice. Then other question arises. Now, is 36,000 is not the figure ultimately.
Pardon?
36,000 are not the figure of. If you pass the judgment, all right, then this petitioners told the learned judge that it should be 32,000. Learned judge, very well, I'm correcting it. See the order. On simply being told by the writ petitioners, the figure should be 32,000 and not 36, he changed it. What the order? Well, order that. Volume, same volume. Will it kindly come to page
627.
627. 6 and 27 of this judgment, of this paper book. This paper book. Correction of typographical mistakes, heading. Similar. Matter has been mentioned for correcting some typographical mistakes. Mr. Tiwari, Sergeant Advocate, point out, etc. I'm omitting that. Kindly come to 2. We're concerned with 2. Mr. Tiwari, you are the counsel for the writ petitioners. Has also mentioned.
Mr. Mitra, one interruption. That first para, that fourth line of paragraph 7, the number should be 13.796.
13.796 and not 14.910.
You argued that those persons, 824 of
Yes.
3 were, and in fact 1 was from SC. He got less than 14. Did he get less than this number, 13.37?
What from he gets it? I've shown you from the.
No, we are.
Even then, they didn't get 13. They're all 12. 12 point. 12 point.
No,
After
your argument remains because.
Is it typographical error? 14.191 becoming 13.796. Typographical error. It would have been if it was 13.191 by mistake. Typographical error, what will call 14 type just 13.
Yes.
In that this breakup figure, 14.191 becomes 13.796.
Yes.
Just being told by the petitioner's advocate.
627.
What does it show? Great confidence, no doubt in that confidence. Then 2.
Yes.
It is a typical mistake. Yeah. And Miller, I admit without, I should have pointed out to you, Lordship, when I'm arguing that 14 is the.
No, it's all right.
It has been corrected as a typographical error and should be 13.796 as a broken figure. Yes. Now, what is the typical mistake? Court has noted. Then paragraph 2, II. Justice Tiwari has also mentioned that in the paragraph 21, which it was stated appointment of 36,000 candidates, more or less, what is more or less, do not know, who were untrained at time of recruitment 2016 recruitment process are cancelled. Justice Tiwari has submitted that this should be 32,000, more or less, and not 36,000. Such correction is made as it is a typographical mistake. Typewriter mistake, the court has what is typographical mistake? Court has dictated 36,000. Court has dictated how to type, but type is made a mistake. What is a mistake? But court has dictated the minimum mark was 13.796. But typographical typist, instead of typing 13.796, type is at 14.191. Is that believable? Extreme confidence in the advocate, I know. It does not ask any particulars. Show me how it is wrong, why it is correct, incorrect. He does not send for shortened notes, as is normally done by the court. The stenographer shortened notes is sent for. Let us see what you have typed it, what you have written there. Mistake with article section 152. That is clerical typing mistake. He has used the expression. But it's a clear case of modification of the order upon oral submission of the petitioner. It's not a case of correction of typographical mistake. After delivering judgment, after becoming discharges judicial duty and function of official, he now modifies the order. And that's one saying of the petitioners. Would I include? So what's Lordship now realize how or see what happened in this case. I have shown no mistake. 141991 was the correct thing from the chart. Remember that. I have shown to your lordship from the record that 14.19 was the lowest mark from the chart.
But now they are saying it is 13.37.
The petitioner is saying so, therefore it must be so. That's the reasoning. That's the reasoning. And this judgment doesn't require call for many arguments. And now let's come to the question, illegality. What are the scopes of illegality? I have dealt with parawise. It's not so. Before I sit down, I shall show your lordship and the illegalities. What are the summary? And none of them is tenable. None of them is tenable. Only one point I am unable to answer because that is matter of record, board can only say. First ground, paragraph 7, I've dealt with 832, that is the benchmark of 14.191. But nobody was. Then second, board suppressed some particulars. Very good. Is incorrect in fact because board supplied. Paragraph 8. Supplied. 8. But lordship notes what the consequence of suppression is not suppression by the writ petitioner, that writ petitioner dismissed. Suppression by respondent. And what the Court of Justice do? You will draw at the highest adverse inference under section 115. And had this been disclosed, that would have supported petitioner's case. But when petitioner has made out no case, then what happens? Is the ground for allowing the writ petition? Then next ground is no aptitude test taken. By 9 to 14. What is the aptitude test taken? Basis is oral evidence. It is not a case made out in the writ petition. It is not a case made out in the writ petition. No aptitude test taken is not the case. Because all the petitioners got aptitude marks. More or less or more.
Yes.
Yes. Now, what the basis? Oral evidence. I made my submission, oral evidence has no value, it has no jurisdiction. Without non-parties were cross-examined. Yes. Now, even the oral evidence do not support this conclusion. Why? Only 4 districts out of 20 interviewers of 4 districts out of 20 districts was called for examination. Only 4 out of 20 called for examination. And those called, 9 of them said yes, it was taken.
5 out of 20.
5 was not called for evidence. 5 envelopes were opened, Howrah. Envelopes opened, but ultimately lordship did not think it was proper for him to call Howrah interviewers. For reasons best known to him, he opened 5 envelopes, including Howrah. But at the time of calling the interviewers of all parties, he thought interviewers of Howrah should not be called. Maybe some reason he might have thought they might say something contrary. Maybe evidence may not be contrary. But why only 4 out of 20 districts?
Yes.
Here will not comes a question of law. The court cannot generalize. And for that I rely upon a judgment, 1981 Supreme Court, I shall give the comment. আচ্ছা মুখে বলছি আমি করিনি তো তোমরা করনি কেন? This is a judgment to that effect. I have noted. চুপ করো. That is judgment AIR, All India Report 19 HC 1980 Supreme Court 1896. Court cannot generalize.
Here,
AR 1980 Supreme Court 1896.
no, that is in that compilation you gave.
No, they say
Court has
it was,
exercised
it was Millard, my mistake. I did not tell them.
Oh, 80 Supreme Court is not in the compilation.
No.
Mr. That we.
I give a separate copy for it. Give it, Millard. It is a mistake on my part, and therefore they could not. And I own up the mistake and ask for their forgiveness. But judgment is judgment, Supreme Court. Now let's come to the point. Is out of those interviewers, 9 interviewers did say, yes, aptitude test was taken. And most of them said, I do not know what is the aptitude test. But aptitude test is defined by the rules to test the applicability as a teacher, ability to teach.
Yes.
Here we have another judgment will come into proposition of law. That court cannot reassess the evidence in read court and cannot sit in appeal. Next ground taken is, Millard, that 9-point high marks are given to large number of candidates whose academic score was low. Paragraph only. Not kindly, Millard, and I said before saying anything else, is that a plausible thing? Is it say that a person who has scored good marks in BA or MA exams, their aptitude will be good. There must be a good aptitude. Academic results, is it linked to aptitude test? May I give us a crude example? Crude example.
Yes.
Give a crude example, Millard. There are many amongst us here was done excellently well in academic examination, BLLB, all examinations. But their aptitude towards practice in law has been different. I can give the example by name, I don't give. So, people can anyway. So, doing it, suppose one has got BA first class, first, BLLB first class first. He will be first lawyer in the court. This is an absurd thing, assumption. Aptitude is something else. A degree gives you academic qualification. You may have aptitude for teaching. You may not have. You may have aptitude for drawing. You may have aptitude for law, practicing. Which is, surmise is totally wrong. Then I shall say factually also wrong. Why? I give you mostly that academic qualifications and mark, 4 out of 3 read petitioners got academic score so much and they got full mark.
4 read petitions.
3 read petitions.
Okay.
उधर कॉपी दाओ मैं के देखे नहीं page etc given academic scored so much and they got almost full marks. 5.5, 4.5 and 4.4. I am showing you the only thing that 3 cases, the writ petitioners themselves got the highest aptitude mark. The next thing to be considered on this score. Next thing you consider.
Your Lordship's kind leave, may I unhesitatingly give a reverse situation. Mr. Shankodas Banerjee had once told in open court that I got a third class in naming.
Third class?
Third class in naming.
Achha.
And then I was very sad, but I don't regret that marks I got in my examination. He got third class in naming.
LLB did a good treatment.
That was the naming.
We have got many.
It's primary teacher, not LLB.
Number two, have got many first class.
Just a different situation. Academic and the practical.
No, like we say, this master's qualification in LLM, many would say that this does not help the person in practicing.
LLM or doctorate.
LLM or doctorate.
But the question is this: knowledge is one thing, you get virtue. But the power to transmit my knowledge to the students, that is another art. I have known lawyers of great knowledge of law, advocacy poor. They cannot transmit their knowledge of law. They are not successful. Great knowledge of law. I don't have to. Many. Mr. Hemnath Sannal, one of them, a great lawyer. Knowledge of law is something. Knowledge is one thing. But power to transmit the knowledge to others is another ability. Lesser knowledge perhaps helps that. A teaching ability is that. Transmit your knowledge to the students. Next point, below this. Next choral thing. Next point is below. Out of 50 marks, only 10 marks are involved in interview and aptitude test. 5 marks. 5 marks. Other 40 marks are arithmetical calculation. If you get a first class in BA, your mark will so much, etc. So, if for the 5 marks, the 50 marks calculation, it will be quashed. How far it is relevant? The aptitude test marking was wrong. How about wrong? And secondly, my lord, I must have appreciated by now, the court cannot say that the result aptitude test of the interviewers, I can sit in appeal and say is wrong. Court cannot sit in appeal over the reports of interviewers and say I'm wrong. This is law, not judgment will be there. Judgment is there, we should go there. Now comes the last point. Substitution. What is the last point? That last but one point. Next point is no empanelment of candidates in reserved category in the panel of general category. Paragraph 15. How does it affect? Paragraph 15. Yes. Now, this is a ground. Again, no pleading. Again, judge's case. This is in paragraph 15 of judgment of Sugeti. 15. 15 of judgment. No pleading. But court's basis is board has not given a reply in respect of the allegation of petitioner in the pleadings as to non-compliance of reserved category candidate in the panel. See, at page 621. 621, paragraph 15. Board has not given a reply to of the allegation petitioner in the pleadings. There is no such pleading. No question of pleading. No such pleading. Rajesh will correct me. The petitioner, I welcome his correction right now. But we have checked, have missed it. And as to non-cut, therefore, it has been done, must have been done. Yes. This is how. This is which means candidate who have got better marks than general category is panel for general category mark to those reserve category candidates who got better marks than the general category candidate in open competition. Thus, the board has violated the law declared. How far did it affect the writ petitioners? How far it did affect the results? In that spiral, there is a reference. Should I take your lordship time to show the spiral? What they've shown.
What?
In the spiral, there is a reference.
Reference
of this is to Purve. There is showing that these are the SC candidates who got higher marks than the general category candidates. Yes, they have given. You look at it, you will find that all those SC candidates have all been employed and given appointment letters. Why I tell you? Because in that spiral, they disclose the breakup of marks of those candidates. And breakup of marks were disclosed by the board only in respect of successful candidates. So they are not affected. If you want to see that, I can show you a lot. So, it's useless exercise by the court. There's a paragraph, বার করো ওটা দেখেছি আমি তুমি দেখেছি প্যারাগ্রাফ পেজটা বার করে দাও এই
There were in which district? Do you know how many?
I don't. No, nothing is in the petition.
Please
nothing in the petition.
So, Mr. Mitra, please show us that paper.
Spiral, from the spiral. Yes, spiral. I'm looking for the paragraph. Bar kore dao na. Huh? 153. Acha. Please will not come to 153 of the volume 1. Yes, they have given a number of 42 candidates, 42 SC candidates. 42 out of 1 lakh candidates, out of 32 successful candidates. And all of them, have given the TET score, MP score, higher secondary score.
All appointed. This is only in respect of Murshidabad.
Yes, that's what they've given. I'm showing, even then it shows that those ST candidates were all given employment.
In all the districts?
Yes, because I'm telling you, this is no off the record. The breakup of the score made by the candidates were disclosed by the board only in respect of successful candidates. And they've given the breakup of the score. That shows these are all successful candidates. They've given the breakup score, TET score, Madhyamik score, higher secondary, then Viva marks, aptitude marks, everything given.
Yes.
They're all successful candidates. Now, where was the fault then? Whether they actually given employment, got it. And none of them is complaining, my lord. None of them has come forward. None of this has come forward and make a complaint about the alleged non-empanelment in the general category. None of them is complaining. Why not? Because after getting the option to get the general category, none of them has complained. None of them is writ petitioner. 5 years have passed. So, Is there a ground for causing election? Now, last ground is no selection committee was appointed. That's also a new ground, new point. A new point by the judge. So, no wait, nothing. I am unable to say anything. Both can say. Which will matter of record, let both say. Both say. Bolo. You say so. Bolo.
They could not say that no selection committee was constituted.
No. Selection committee was constituted. Subcommittees were constituted.
No.
If, once my concludes, I shall.
Thank you. I'll throw another.
No, we have heard you. Let us see. Now we have to see those allegations which have
Only
been.
I'll take 5 minutes.
No, Mr. You will get your chance in reply. We will hear you. If it is published, not published. That's it. All right. Yes. So this about no selection committee, there is no pleading also in the writ petition.
No
That is
selection
what-
committee, judge is saying another thing. It's for the board to say. I do not say. Now, it's a question of fact. If the petitioners do not allege that no selection committee was
That is what we are asking.
No,
No selection committee averment is not
not
there.
in the petition. So the board on affidavit could not deal with this. Board in the affidavit could not deal. If the court asked a question to the board, then board could have said.
Thank you. Yes.
Now, my lord, I humble submission on this second point is, court has on this aspect relied on wrong rules. Please see the judgment, paragraph 1 and 2. It relied on a rule regarding selection committee and all that. Rule 7. Rule 7 was amended, which the judge has not taken note of. He has gone on the basis of unamended rules.
Which paragraph?
Page 611.
Rule 7 is in para
Was
16.
amended.
Paragraph 16, rule 7.
6.3. It is a rule
6.2.
6.3. This
Paragraph
relaxation.
Paragraph 16 is rule 7.
Okay. Now, please will not come to paragraph 17. 17 of judgment, yes.
Amended with
17. I'll give the date. Yes. And we have got the amended rules. To your lordship. What I would 79?
no, amendment was, I think, that
17 is what to bolo. 17, 16 bolo. 16. Now, he has relied on, learned judge only relied on paragraph 16 of the judgment 622. Has relied on this. I have dealt with. Now, he relied on relevant rule 7 of required rules, mandate constitutional selection committee, no selection committee was constituted. This is a rule prevailing before amendment, before the selection process started. Can you take the two dates? This rule, which annexed to a writ petition, that was amended before commencement of selection process. On 21st September, copy there, 23rd September 2016, Rule 7 was amended. Substantial amendment, giving power to make subcommittees. And I'm told these amended rules have been 23rd September 2016. And the advertisement was issued on
26 September.
And what I'm told this 216 selection process was initiated by issue of notice or advertisement on 26 September. Page 40. And paragraph 16 of the judgment relies on a rule, relevant rules, Rule 17. I'm told handed copy is given to your lordship. They have just
the advertisement.
Lordship. The rules copy has been given to your lordship previously. And they'll also get the date of amendment, etc.
Near now. Yes.
On this point, the next point is this, Madam. On this point, selection committee, the court, Honorable First Court, did not give any opportunity to the board to say whether selection committee was constituted or not. From the judgment, it doesn't appear to be so.
No allegation was there.
No, that's why.
That you have argued.
Asking the board, Lordship, Milord should have said, paragraph 16, no allegations there, but this case struck me. I asked the board, have you constituted selection committee? Board said no. Then I could have understood. It would have been fairness in justice. There's nothing in the paragraph to indicate board was asked and board said no, we did not consider. Milord, I'm coming to end the word. Milord, may I cite one judgment which is unreported, given by a coordinate bench, your lordship, a predecessor coordinate bench, regarding this very selection procedure of 2012, 2014. 2014. This is the judgment, Milord, and see, Milord, under similar, their lordship held that the selection was made in violation of NCT rules. Held so. But lordship, what the view of the division bench? This same thing. His challenge was made, writ petition challenge was made after 5 years, as in our case. Court said, we've allowed this arrangement to continue for more than 5 years. Now, if I set aside selection on this ground, it will upset the understanding which is going on there. First is, Milord, first paragraph. Propriety of the first teacher eligibility test conducted in the state is called into question in present proceedings. Examination for the year 2012 was held on March 31, 2013. In our case, I give the appellants assailed the judgment and order of February 26, 2016, by which their petition and Article 20 was rejected. And this was upheld by the court. See what reasoning? Date is given. And then court holds, yes, there was NCT violation. Paragraph 2. State was held in March 31. According to the state, nearly 30 lakhs candidates took examination. Is also a mission of the state that appointment to more than 17,000 primary school teachers. In our case, Milord, 32,000, according to learned judge. According to writ petitioner, so to say, according to writ petitioner, as adopted by the learned judge, have been given on the basis of 220 test. Subsequently, the process of appointment has been delinked from TET, and passing of TET is now an essential eligibility criteria for appointment of primary teacher. Now, Lord, please come to Lord, the relevant part of the judgment. Yes. Paragraph 15. In other words, conclusion, the irregularity or illegality on the part of the state in providing for a mode of examination which is at variance with the guidelines issued by NCTE is a matter that must not be missed. But the present appellant challenged the propriety of TET 2012 cannot be assessed on such ground since appellant chose to sit for the examination. Here the same case with full knowledge, same fact that the mode of conduct examination was variance NCTE. All route guidelines, everything is right. As to binding nature of NCTE guidelines, appellants refer to division bench judgment of this court, rendered matter of Sir Raja Chatterjee's case. In the judgment pronounced in August 13, 2015, the question that failed for constitutional division bench in that case was whether the duration of TET could be 90 minutes instead of what has been prescribed in the guidelines of February 11, 2011 by NCTE. This court clearly held in such case, if the test is to be held as per the guidelines, it follows the test has to be held as per the amendments made to the guidelines from time to time, unless legal issue amendment challenged. Then paragraph 19, the court holds there is a violation. Paragraph 19. In the light of the both division bench of this court and the Supreme Court declaring that guidelines issued by NCTE for TET are binding, is not open to the state to contend to the contrary or seek justified TET 2012. But to repeat, the challenge in this case has to be limited to the examination itself and not the mode of conduct thereof, the duration thereof, or the total marks allotted therein. Then before single verse, can you see me the paragraph 22 now? Now, because what order come? In the light of the aforesaid, it is apparent that TET 2012 was not conducted in accordance with the binding NCTE guidelines. However, it must also not to be lost sight of that TET 2012 was completed in the year 2013 and was held as an eligibility appointment test in the state, pursuant to which 17,000 vacancies at the primary school level have been filled up. These thousands of teachers have been entrenched in their position for nearly 5 years. In our case, now it's 8 years. Now 8 years. In addition, TET 2012 was a huge exercise, particularly since it was for the first time that such eligibility test was conducted in the state. About 30 lakhs candidates appeared. In our case, more than that appeared. Then, my lord, paragraph 23. Principal reason furnished in the judgment, etc., is and to that appellant having taken part in the examination were not compelled to challenge cannot be accepted. Cannot be accepted. That was not accepted. Then, my lord, paragraph 24 and 25 and 26. Court did not disturb. In dealing with a matter of such proportion, a larger picture must never be forgotten. Same is my argument, submission here. There are some 19 or so appellants in this case, out of nearly 30 lakhs. In our case, 140 out of how many lakhs? 120,000 who took state instance. Who have stayed back to pursue the challenge, stayed back. Even though it might not be proper to presume that overwhelming majority of the candidates accepted TET for its validity. What is important is that only there is an insignificant minority has come to the challenge. In minority, 130 out of how many lakhs? 120,000. Then, my lord, instead of robustly repelling the challenge, board and the state have graciously accepted that there are irregularities in several questions in respect of different subjects in TET State has also accepted the action may be issued in its court to hold any future state strictly in accordance with the prevailing NCT guideline. State has also offered the number 27 order. In the backdrop of the state's stand, the appellants only appeal to the court to allow additional marks to be allotted in TET 2012. For such of the question, we did not adhere to NCT. We not let them additional marks to be given. Earned by the may make them eligible and be considered as state passed. However, if such course action now adopted in this court, it would disrupt. This is my submission. Disrupt the entire system for all the other candidates would then be rightfully claimed additional marks and seek to clamber over my 26%. Then, in the circumstances, it is deemed just and fit and convenient to notice that there were serious irregularities in the conduct of TET 2012, both as to mode and the examination, and as to the question set therefore. The state is directed to ensure that future TET examinations are conducted strictly in accordance with the prevailing NCT guideline in such regard. TET 2012 and the results of TET 2012 are left undisturbed because of brighter and more wider question. Is educational system of a state is involved. And the system is going on for last 8 years now. They came after 5 years. So even if there has been violation of rule, which I do not admit, I said no violation of rule, even if violation of some rule, various questions arise, which is mandatory, is that deficient, and whether it should be done now when on the basis of the selected candidates have held office and act as teacher since April 2017 they have been appointed. And now we are in the year 2025. 8 years have passed. They came to court after 5 years, as in this case. On that ground, I am placing before Lordship, adopting this judgment. I place a broader question before Lordship. In the broad interest of the state, the education system, will those systems be disrupted now? Even if there's some, maybe violation rule, there's none. But no question of corruption in the selection process. That is out of question here, up to 2016. There is no question of corruption. Then why should it be done? Is it not? Your coordinate bench did only 7 years back. Under similar circumstances, assuming there's a violation of any rule, assuming, even then, a system continuing, that I will humbly submit below, coming to an end below. In the writ petition, lot of arguments are normally made, court can mold the relief, etc., etc., etc. It's not a question of molding the relief. It's a question of addition of a totally new relief. New relief. And Miller has been held by Supreme Court that new relief, which is not claimed in the petition, cannot be granted by the court to the prejudice of the parties. A new relief can be granted which does not cause any prejudice. Maybe. But this is number one. The judgment 1991 SCC, I'll give that judgment. Number two, a court the avoidment of judgment cited court mold the relief, etc. Next, number two, why the court could not do it? A court cannot create a new prayer, a new relief, and grant a new relief, which will be in violation of natural justice and be void. Namely, an order to be passed by the court against non-parties who had no opportunity to appear, who had not given any notice. A judgment has been cited by Mr. Kalyan Bandyopadhyay on this 2014 SEC, and there are other judgments, galore judgment we can cite, but do not multiply. But this particular matter, my lord, even assuming there's illegality, everything, court could not pass any order annulling the appointments of 32 persons who were not made parties, whose representatives were not made parties, and the writ petition was not made in representative character. As observed by Supreme Court in such cases, huge number of us involved, then make 2 or 3 representatives, issue a notice in the newspaper, advertise, and then order on Rule 8 principles will apply. Therefore, that is without jurisdiction. And this new relief annulment should in any event, apart from going to any further, should be annulled on the ground of injustice, principle of natural justice violation. That's these 2 judgments. I give the in my edition and give a review to learned friend, others and give a copy of that judgment.
These 2 judgments.
Not in the compilation below. 1991 Supreme Court and this division main judgment.
Mr. Mitra, please make as Mr. Bandyopadhyay has given us the judgment, the point in which point you are citing the judgment and the paragraphs of those.
That I've told them.
You can give us a copy.
Lordship, the next day, Lordship allow us to have the index of the judgment. I will give the index mentioning the keywords. Why the keyword? Then the judgment for this, the no order against non-parties. Like this. So that Lordship can.
Yes, sir.
That's I'll add that.
Thank you.
That I have to do personally.
Officer will allow my clerk to just change the index.
Pardon?
Change the index.
Which one?
For the compilation, I have already
আমার নিয়ে গেছিলাম।
আচ্ছা তারপর আরেকটা ইন্ডেক্স মেরে দেব এখন কি আছে?
You have given us this দাও একটুখানি
compilation without keywords.
Printed compilation একটা দিয়েছিল। এই যে উপরেরটা কাটতি। হ্যাঁ।
কম্পিটিশন ওটাই দেবে ইন্ডেক্সটা করতে দেবে ওটা মেরে দেবে তার।
You have given us this compilation.
Lordship, we are my senior has added.
Please give
keywords are not there. You could not allow me.
And copy তোমাদের দিয়ে দেব।
না এটা থাকবে। Do you want it back?
No. I will come with the fresh one. Changing the index.
Yes, no, then let it be with us because
no, don't allow that. I'll give an additional index which will be super special. ঠিক আছে. Okay. Oh, grateful to my Lord. Indicating this.